was absolutely from beginning to ending. I mean, it was a whole host of what I call madness, a complete waste of judicial time. All the witnesses, if they have 3 pages of their statement, only a paragraph or a half, or that they could have been able to speak to, because everything else was an embarrassment to the hearsay rule. So they could not be lawfully allowed to give that evidence. I mean, any person looking at that file with legal training would know that, and would know that even though you have those things in your statement, it cannot be said, because many of the witnesses that they sought to give to surround this investigation around is you find could not speak to the specific time. And I keep repeating this on many courts, and I keep saying there is this whole thing about you demitted office and you are unable to find documents, and therefore it means that something fraudulent took place. The absence, and it's strike law, the absence of a document or record is not prima facie evidence that the document did not exist. So if you are not going to, and you could not premise this entire charge to say, well, no contract was there. No, and this is why I keep asking. You pass through an entire legal team that must know that you can either have a written contract or an oral contract. And so being, you mean to say that persons are reviewing a standing order without authority, but using the premises that you're in control of, using the resources that you are in control of, and would have at least taken persons from the various departments to do work. I mean, come on. It is absolutely ridiculous. Now, they had a computer in which this laptop was used to record the various changes and so on. Now, you brought an entire laptop, but absolutely no analysis. Now, you come to say to the court that the amount, because this is their evidence, they were never saying that the amount of standing review of the standing orders were not found in this laptop. They were actually saying, I mean, that is what the prosecution was attempting to do, to say some of it was found. Now, if some of it was found, I mean, come on, it must have been, you must have considered that you can't be saying these persons were not authorized to conduct these reviews. There is no contract to support that, but some of it was done. Then what are you talking about? If you're, and that is why I asked the police investigator Romana very clearly. I said, are you saying that the reviews actually was done, but the amount of reviews, the amount of the standing orders that you were expecting, equating to that money, was not done? So you're saying that monies were collected, but work was not done to its totality. He didn't even know. He went back to say it was not done. And I keep saying, but I don't understand. How can you be saying work was not done when you are in possession of the works done? If the work was not done to the satisfaction of the police force, then that is a total different argument altogether. But they were not saying that. They decided that they were going to hold on to say work was not done. And work was not done on the basis that the persons were not authorized to do the work. My gosh, I could not believe that. I could not believe that is the level, and this is what I'm saying. And I want to read from the code that we are guided by as the code for prosecutors. And you see, this is a very important code, because it's not only the persons charged who are usually affected, but their entire family, their friends, their community is affected by this thing. So instituting of a charge against someone is a very serious thing. And we have taken this thing too lightly in Guyana. Persons are getting charged left, right, and center. I am waiting for some matters to complete in the court. And when it actually gets to high court, and I am now the attorney standing representing the accused, I am just as baffled as the judge. How did this matter get passed? How did this matter get passed? How did this matter get to court? I've had too many of that. Because there is absolutely no care and no thoroughness in how matters are reviewed. Criminal matters are reviewed in Guyana. Now, in most cases, and I'm reading 6.2, and I quote, in most cases, prosecutors should only decide whether to prosecute after the investigation has been completed and after all the available evidence has been reviewed. However, there will be the cases where it's clear prior to the collection and consideration of all the likely evidence that the public interest does not require a prosecution. In these instances, the prosecutors may decide that the case should not proceed. Now, prosecutors should only make the decision when they are satisfied that the broad extent of the criminality has been determined. I asked that question, and I'm sure you remember. When I asked him, why did you charge these persons? Where is the level of criminality you're talking about? Persons are coming and they are reviewing the standing orders. They're interviewing officers and they're making recommendations and changes. Where is the criminality in it? Where is the criminality in it? Huh? Now, if you and look at it. I mean, it is clear that they wanted to someone was setting out to damage the reputation of these of all of you. Because I mean, look at it. If all the persons who sat in the on the board to make a decision to say let the review go ahead, the person who has the responsibility by law would have been the Commissioner of Police. Now you completely no statement at all from the sitting Commissioner of Police, the then sitting Commissioner of Police. No statement at all. Now, right away, I would say, as if I were reviewing the file as to recommend charges, I would say I'm not proceeding with this until I get a statement. Because if this man, by law, has the responsibility for these for these reviews and can order these reviews, and I have no sanction from him, then why am I going to the other parties? Because every other person that I'm using was not there and could not speak to when this decision was made. Now, all the other statements point to the fact that, especially in the handing over of responsibility from Assistant Commissioner Junior Andrews over to I think she was Assistant Superintendent back then, Kendall, when those duties were handed over after he was of course transferred to another area. I mean, again, that would have been enough light bulbs that can go off in your mind to say, man, there was something that was happening. Something that was happening. And therefore, it couldn't be that these persons were defrauding. And then you claim that that y'all was defrauding the police force of over $10 million, but then you did not have one statement from anyone who had issued a check. So really and truly, you went through the entire matter without any person bringing any evidence that you were paid. Where is the record? Where is the record? So on all limbs, And I'm particularly appreciative of the court's ruling today, because the court also touched on the issue of the vouchers that were not allowed in, because the prosecution, of course, was attempting to disclose this after 2 years, and after we had closed that and we were in the trial. And I'm particularly pleased with the court when the court pointed out that even if these vouchers were to be admitted, it would not have advanced the case of the prosecution. Because where is the meeting of the mind? Where is the plan? And who did these persons plan with to defraud the police force? Who? Where? So there was no dishonesty at all. And I think the dishonesty, that element could have been clearly seen from the statements disclosed. And lastly, I mean, this is something that it has really sent home the point again that we really have to be very, very careful when persons are charged in this country. Because blatantly, SOCO withheld important facts. We cannot safely say evidence, because it's only evidence until it gets to the court. But they withheld important facts. Important facts that would have been able, from the preliminaries of this matter, for us to make a preliminary point and have these matters withdrawn or have these matters dismissed. Because the witnesses clearly stated that all the work done by the review committee or persons were available, and they were handed over to SOCO. So they suppressed important and vital facts in this matter, which is clearly the magistrate said the court had to take judicial note of it, because it came out of your case. Your witnesses came and say, I did all these things. And we are left to say, well, then it was never disclosed. It was never told to us that it existed. Because some of the witnesses were even coming and say that it did not exist. But here your witness is coming, your final witness who actually did the typing, come and say, she came and say clearly, yes, it was done. Yes, I did hand it over to SOCO. So they were in, but they were not interested in justice. Justice in the sense. They were not interested in the persons having a fair trial. The amount of things which were trampled on in this case, I think it's a very worrying development.